Now, before we talk about any of our live trials, and as you heard, there's a lot to talk about, how could we not talk about one of the biggest legal issues in the country right now, and that is the Brett Kavanaugh nomination hearing? Because what we had last week was a bombshell report that a college professor has come forward and accused this man of sexual assault back in the 80s. We heard a few details of it back on Wednesday, but now we know who this accuser is. Her name is Christine Blasey Ford, and she is claiming that Mr. Kavanaugh tried to rape her back in the 80s, even covered her mouth to hide her screams. This is a really, really big bombshell report, and I want to talk about it right now with Law&Crime trial analyst Jonna Spilbor. Jonna, good morning to you.
So happy to be here with you, Jesse.
Jonna, how if this story is true, what will this realistically do to Kavanaugh's chances of being confirmed?
All right, so I think we have to analyze this from two sides, right? A, is the story true? What if it is true? And what if every fact that the accuser has come forth with is true? Versus, what if it's not? So, okay, if it is true, what you have to measure is the 35-year-old allegations that a high schooler who was drunk at a party assaulted the accuser, right? If that happened, will that affect whether or not Judge Kavanaugh gets confirmed? I say there is so much evidence to his credit outside of this. He has done so much in his career. He did wonderfully during the confirmation hearings that it probably will not tip the scales outside of his favor, and right now the scales are tipped in his favor.
Well, let me ask you a question. Even if he was super successful, was a highly regarded judge, doesn't mean that this is not true. You look at somebody's entirety of their life, even before he began his legal career. Even it doesn't matter if he was in high school, he could be held accountable for this, and the question is, will he be answering for it in 2018?
See, actually, no, he can't be held accountable for it. He can't be held accountable. Let's say it's true. Let's give her the absolute benefit of the doubt it's true. He can't be held accountable for it criminally. He can't be held accountable for it civilly. All he can do at this point is damage his reputation enough so that he can't work anymore, I suppose. That's really all I can do at this point, because the allegations, Jesse, are older than you.
Well, let me ask you this. How do you verify this from a practical point of view? She didn't come forward with this story until 2012 when she spoke up. I know she's been seeking treatment for it since that time. That's a long gap, but is this a situation where you bring in her therapist and say, look, she is exhibiting the signs of somebody who really did suffer this? Because finding evidence from that back in the 80s can be really tough.
That's a great question, and I think you're right. I think it's almost going to be impossible. This is going to really turn out to be a quintessential she said, he said. Now, we know Judge Kavanaugh has categorically denied these accusations, right? So she's got information over here. He's got a categorical denial of the accusations. Who should get the greater weight? And I believe that's going to be like an individual basis, is it not?
Well, I know that some people have come, well, at least one person has come forward and said that this is, who was there, who knew Kavanaugh back in the day, and said this is not true. I've never seen anything like this, but I'm curious if anybody from her side will come forward and say this is true. We'll have to see this back and forth, but we will talk more about the Kavanaugh sexual assault claim as soon as we get more information. But we want to switch gears here and now talk about our live trials. First trial I want to talk about is the Stanley Liggins case. In case you missed it, here is some testimony from Sherry McCormick. This is the mother of the young victim, 9-year-old Jennifer Ann Lewis. Let's find out what happened back in the day. All right, so that's some of the testimony from the victim's mother in the Stanley Liggins case, which will be live today, but you can go to lawandcrime.com to watch it. Back here with Jonna. What does the defense need to do today, if anything? Because we believe the prosecution is concluding their case today.
Yeah, right. So this is the point of a trial that most defense attorneys have to face, and that is, do you do nothing and rest your defense on the fact that the prosecution didn't do what it had to do, it didn't meet its burden of proof, or do you put on a case? And in this situation, because we have such old allegations, this is the third rodeo for this defendant. Not that that matters. It's highly likely that the defense might just say, you know what? we don't think the prosecution has met its burden, we're not going to put on a case.
Well, they didn't present we're going to have to see what they ultimately do, because this is a very interesting case to follow. I want to play a little bit more of Sherry McCormick's testimony, and this is where she gets into when Jennifer disappeared and how Stanley was at her house. Take a look. That's Sherry McCormick recounting every mother's worst nightmare. Jonna, when you look at this case, what from a forensic standpoint really is there? I mean, you have witnesses who say he was at the party, he was there that night, last seen when she was last seen, but what do we have tying him to the victim?
Yeah, see, that's the elephant in the room in this case, because forensically there isn't a whole lot. We have a lot of circumstantial evidence, and people get convicted on circumstance all the time. But we don't have a lot of science connecting this defendant to the actual murder. So that's going to be the biggest question jurors are going to grapple with.
He was convicted 2 other times.
Yes.
They obviously felt there was something. Was it the gas can in his car? Was it his proximity to the victim? What was it?
So that's, you hit on it. What the jury's going to have to do is add up all of the small circumstantial things that could make him the killer. The gas can, the proximity, the witnesses who say they saw her in the car itself, the fact that the weird gray material on her body, perhaps matching material that he had in his home. So those are the things that the jury's going to have to put together by connecting all of those dots.
And that is going to be something to watch, how they connect this, if anything, and what will the defense do? Will they call any witnesses? Will they call Stanley Liggins to the stand? Who knows? We've seen stranger things happen here on Law and Crime. When we get back, though, we are going to recap a little bit of the Brad Fields case out of Michigan, including the text messages between him and the victim's mother. And let me tell you something, it's not good for the defense. We'll be right back. Wow. That's the conversation between the 2 people that were supposed to be taking care of young 4-year-old Gabby Barrett. Jonna, I'm just going to ask you straight up, gut reaction listening to that text message conversation between the victim's mother and her boyfriend.
Yeah, and I'm going to tell you straight up that I am going to have a tough time covering this case without welling up. It's that heartbreaking to me personally, as a person, as an attorney, as a woman. It's disgusting. That's my gut reaction. It's just disgusting.
And how does the defense, who are saying, hey, the real person who's to blame for the death of this young girl is the mother, is Candace, how do they translate that series of conversations and move the responsibility over to Candace?
You know, I suppose the defense is doing what it has to do, where you're going to have this side pointing a finger at that side. Whenever you have co-defendants, that's a typical defense strategy. But in a case like this, where you see text messages like that show the mother is quite complicit in the abuse and what was going on, and certainly didn't do anything to stop it. And so I don't think the strategy in this case is going to work. Obviously, though, I will say this. If there is one tiny mitigating factor that you're starting to see in this evidence, it's that, I don't know how to say this nicely, maybe they're not all that mentally there. Not that they're mentally incompetent, that they have maybe some emotional issues, because, you know, they're young people themselves talking about abusing a child because she has to urinate.
Well, unfortunately, what we just played for our viewers was only the tip of the iceberg. I'm about to play some more messages, and I tell you right now, it gets worse. These are the series of Facebook messages between the defendant and the victim's mother, the 2 people that were supposed to take care of this young 4-year-old girl. 4 years old. And do you hear the conversations that they're having about her? Jonna, I mean, we're lucky. We're lucky we live in 2018 where you can have these kinds of messages on a social media app, because don't these messages, more than anything, really capture the psyche of these 2 individuals?
They're definitely capturing something. And what's really disturbing and remarkable to me is, as we go through them, it feels like these 2 people were bonding. Like this was their common thing over the discipline and abuse of this young girl. So as long as they had a reason to abuse and discipline this young child for doing what young children do, they were growing closer. I mean, that's the feeling I'm getting as we go through these just disgusting and heart-wrenching messages.
Talk about a match made in, I guess everybody can use their imagination for there. But again, all that matters, though, is what happened on that particular moment, that particular day when she died, right?
Right. And, you know, I suppose part of the strategy could be, well, all right, if the biological mother is the one who physically brought about the death of this child, then this particular defendant has a defense. But you know that they were acting in concert, and I'm sure when the jury instructions come down, there's going to be an instruction to that. So he's not going to get off scot-free, even if it were the mother who did the actual drowning or caused the death.
Because we see so many of these cases where a young child dies, they're in the custody of a parent or parents or individuals, guardians. You have to hold them accountable. Why should a 4-year-old girl die in this manner?
Right.
We're going to take a break, but when we come back, we're going to talk about our other case out of Texas, the Cody Lott case. Stay tuned. Pretty incredible to get the surviving victim to testify against the defendant. Jonna, that is a rarity that's always good for the prosecution. I mean, this is a girl who was shot.
Yeah.
She's looking at her, the person she says did this, and telling it for the whole world. Yeah, no, this is very good, incredible evidence for the prosecution. And my hat's off to this young victim being able to get, most people now, she's what, 15 or 16 years old. This happened when she was 13 or 14. Most people are worried about who they're going to the prom with, not do I have to take the stand and testify in front of a bunch of strangers who I don't know about the day I nearly died and my good friend did. So what's the defense doing? Why didn't they put forward an opening statement? If we believe they're going to go with the insanity defense, are they still trying to see what the prosecution's case will ultimately be? So the defense strategy here has been pretty intricate because early on, what the defense was trying to do is what we all try to do when we're defending a serious crime is we look at the evidence and we try to determine whether we can get any of it suppressed. Because if you're successful, then there's less evidence that the prosecution gets to use against your client. It wasn't a successful strategy here because he wasn't able to get out the confession, for example, and other things like that. So step two is, well, what do I have to work with now? Aha, the insanity defense. So I think this defense attorney, this defense team, is slowly playing this to see how it's going to work out in the prosecution's case in chief. Okay, let's play a little bit more of the extremely emotional and powerful testimony of Michaela Smith. She's about to talk about, she gets shot. What happens next? That's the testimony of Michaela Smith, the surviving victim in the Cody Lott case. Jonna, when I watch that, I can't help but realize this is a girl who's describing what she did right after getting shot. Yeah. How does that even happen? How does someone even get the energy to move forward after that? How does someone, especially a 13-year-old child, in a situation like that, who herself was shot and trying to figure out how to help her friend who was laying there with multiple gunshot wounds? The age, they were 13, the defendant was 22. Does that hurt his case, the age difference? Well, I mean, obviously, whenever you shoot an innocent child or innocent children, I don't think that's going to help. I mean, he wasn't, I think, was he at the time? Was he 22 at the time? Was he maybe 19? He was older than 22. Yeah, he might have been 20. And the question is, because also I think he had, by accounts, he was obsessed or really was into Lauren Landavazo, the girl he shot. But that's a weird mixture, too. You have underage girls and him. Oh, yes, and that's really going to undermine his potential insanity defense, because remember, in order to prove insanity, you got to prove that he didn't know what he was doing was wrong. And he had previously stated that he was mad because he didn't have a girlfriend and he had an interest in this young victim who was not reciprocating. Can't you say that it's not just he didn't know it was wrong, but hey, he knew it was wrong, but he couldn't control his actions because he suffers from some sort of mental disease? I think in Texas, the standard is he has to believe that what he was doing was not wrong. Not the irresistible impulse test, the Monotone rule. And in other words, that's a pretty difficult thing to prove. Very difficult. And I know you don't remember this case, but people in Texas might remember Andrea Yates, 5 children, killed them all while her husband was at work, not guilty by reason of insanity in Texas. Since then, I don't know if we've ever seen a successful insanity defense. I'll have to Google that. But that was a very heart-wrenching case as well. And again, they haven't asserted it as of yet. We're still waiting to see what their strategy is. When we come back, we're going to play the testimony of one of the other witnesses to the shooting. We'll be right back. What a key witness for the prosecution, identifying the defendant as the shooter. Jonna, again, what is the defense going to do here? Say, hey, you know what? maybe they can identify him as the shooter. But based upon the evidence and the medical examiner, how do we know this was an intentional shooting? How do we know this is murder? Is that one way that they might go?
I don't think that's the way. I think it doesn't really matter at this point that we are identifying the shooter vis-a-vis the prosecution witnesses, because I really do think the only defense that this defense camp can present is an insanity defense. There's just a mountain of evidence against their client, and there's also a lot of evidence that there's something wrong with him and has been for a while.
Well, what evidence? Do you need a physician to come on the stand?
You're going to have experts come on the stand. All of his psychological records will come in. An expert has to analyze that.
People who knew him, people know him.
People who know. I mean, his own father knew that there was something wrong, and unfortunately didn't do enough to keep a firearm away from his son. That's something that should be looked at as well.
Yeah, that's definitely true. Okay, so Jonna talked about the mountain of evidence that the prosecution has right now. One of the other key pieces of evidence was the testimony from Garrett Farmer, who also witnessed the shooting. And in case you missed that testimony, you're going to want to watch it. Take a look. That was Garrett Farmer, another witness explaining the events of that shooting. And speaking of shootings, Jonna, from a defense perspective, are those always good because you can poke holes in, hey, it was very chaotic, who knew and who saw what they saw?
Sometimes. In a case like this, however, I don't think so. I mean, really, we have a defendant who was, pardon the phrase, dead to rights. I mean, there's no question that it was him. It was no question that he shot. It's no question that they were targeted. There's no question of that yet. I really think the only remaining question at the end of the day will be, was he legally responsible for a lack of sanity or not?
Well, that is the question, and that is one of the cases. We will talk a lot more about our other trials when we get back. And welcome back, everybody. So we have a very busy day here on Law and Crime. We're talking about a lot of live trials, including the Jason Van Dyke case out of Illinois. We're very excited to present this to you because it is a case that has captured the nation's attention. It is another, unfortunately, police-involved shooting, and the question is whether or not this was a reasonable use of force. What we do know is that there is a victim, 17-year-old Laquan McDonald. But the question was he a threat to officers that night? I want to give you an update that the judge still has to rule on the defense's motion for a change of venue. Most people believe that he will deny this because the question is, how can the defense argue that they can't get a jury when they have 16 who have just been seated? And I guess I'll ask Jonna Spilbor that. How can they do that? How can they argue that?
All right, so let me tell you, here's my impression. When I did my research and I looked at the backgrounds of the jurors that they did get, this has got to be the worst jury for the defense ever known to humankind. One of those jurors, Jesse, has a partner who works in family services, who worked directly with the victim. Now, I don't know about you, but my experience with people who work for family services is that they don't take too kindly to people that they care for getting shot, whether it's by police or anybody else. I don't know how that juror is going to be fair and impartial. I honestly don't. And there are a few other jurors on there that raised red flags to me that the defense tried to challenge, and the judge said no.
One other thing to note is we are talking about a white defendant and an African-American victim, and one of the jurors, only one of the 16, is African-American. I'm not sure how race or racial relations will play into this case, but it is something to think about whenever we have these situations. We will present the Van Dyke case to you once it's live. But in the meantime, I want to take a step back and talk more about the Cody Lott case out of Texas. Right now, here's the testimony of Jamie Lopez. She was a nurse who helped these two 13-year-old girls once they were shot. Take a look. So difficult. So difficult. This is the nurse who was responding to these two 13-year-old girls that were shot. Jonna, when we listen to this, and you hear these shooting kinds of cases, how does either trying these cases as the prosecution or even defending it, how is that shooting case, how are those different from other traditional criminal cases?
Well, I mean, I think the thing that sets this case apart from run-of-the-mill criminal cases, if you will, are that you have two very young victims, one of whom didn't have a chance. But let me also say something, and again, with my criminal defense hat on right now, I don't know if the testimony from this nurse was actually that necessary, because I think what she really is she's kind of playing on the emotions. You know, her eyes were open. She had pretty blue eyes. We know how this child died.
Right.
We know who the alleged shooter is. There's no question about cause or manner of death. So I'm not sure what evidence this nurse brought that the jury needs to hear that we don't know from another source.
Well, the prosecution is building their case. We have to see which way they will go. And this didn't, I'll tell you one thing, it didn't hurt their case, definitely helped their case, but it really doesn't help the defense. I want to play now the testimony of a crime scene technician who testified earlier in this case as well. Take a look. Okay, so the content of what this crime scene technician is testifying to is very important, but it's weird, Jonna. Right before we played this, you had said how some of the commentary is not necessary, maybe should have even been objected to by the defense.
Right.
Clear example there. Why does it matter if she has children and how if this is emotional to her? Clearly it is, and I understand why. But is that appropriate for the jury to hear?
No, I don't think it's appropriate at all. And it also puts in the minds of the jurors. Well, I'm sure there are some mothers and parents, fathers on that jury. Like, for some reason now they're supposed to sit up and take notice in this for this emotional testimony. I really don't know where they're going with it. And I also am curious, you know, this type of testimony is hard to cross-examine, and maybe that's why the defense doesn't seem to be doing too much of it, because it's just hard. Like, cross-examining the surviving victim, for example, I wouldn't have done any. I would not have done any. I would have let that victim get off the stand and moved on to the next.
Yeah, like what are you going to ask? Are you sure you were shot?
Oh, yeah.
I mean, it's a really ridiculous scenario. But we keep playing the chronology of how this all happened, people who investigated the victims. Let's move on to Joanne Ramirez, who called the police on the defendant. Take a look. Okay, so I'll tell you what, we're going to wait for that. I'm getting a report that we are live in a courtroom. I just want to confirm which one we're live in. Oh, okay, great. We're live in the Cody Lott case, speaking of it ourselves. Let's go live into that Texas courtroom. Okay, so the motion for a change of venue and the motion to discharge the jury were both denied by the judge. Jonna, you think that was a proper ruling?
No, I think this is horrendous for the defense. This is really, really going to hurt. This is a jury that you've got one member of this jury who basically has a personal connection to the victim. That is unheard of. That is unfair to the defendant. I don't agree with this ruling at all.
There's an update that prosecutors have dismissed 4 of the 6 murder charges against the defendant. We believe that this is a very common thing that happens in criminal trials, but it is an update nonetheless, Jonna, in this case. And this is definitely going to be one to watch. What are you looking for on the first day?
Oh, boy. Well, I think the prosecution is going to come out, you know, with guns blazing. Again, no pun intended. I mean, these cases are hard. Cops go to work. They are charged with the authority to kill people under certain circumstances. To charge them as defendants when that happens is always rough, both sides.
Well, this former officer is charged with 2 counts of first-degree murder, 16 counts of aggravated battery, and 1 count of official misconduct. A lot at stake here. We'll be right back. Stay tuned. All right, by my count, I think that's 4 motions the defense just lost today. I'm back here with Jonna Spilbor. Not a great day for the defense. So now the prosecution can put in all this evidence about reloading and what other officers were doing, right? That's not good for their case.
Well, not a great day for the defense. But when you're a defense attorney, you get accustomed to losing things that you believe you should win. And what they're really doing here is they're making sure that on appeal, should he not get acquitted, that they have covered all their bases. And they're doing a great job of that. I don't agree with all these rulings either, but it's what the defense has to do.
Jonna, quick 20 seconds. Do you think the defendant can get a fair trial?
No way. That's my legalese. No way. Not in this case. I think the jury is so stacked against him. It's really unfortunate for this defendant.
We'll have to see. But Jonna Spilbor, thank you so much for coming on and speaking about all of our live trials.
Thanks, Jesse.
All right. We are going to take a break. But when we come back, we'll be live in Jason Van Dyke, one of the biggest cases in the country. Stay tuned.